You probably don't realize how lucky you are if you applied for DACA before turning 18 years old and then got approved. Most people in your shoes are terrified to leave the United States because if they do, they might get hit with a 3 or 10-year reentry bar. But if you applied for DACA early and you kept it current, you likely have 0 days of unlawful presence on your record. And you avoided starting the unlawful presence clock after turning 18 years old, which is really crucial if you never let your DACA lapse. This video explains what that means, why is it such a rare advantage, and how it could open a path to residency through work. So you don't lose out on career or visa opportunities just because no one told you how powerful your clean record really is. Hi, I'm Zyra Solano, founder of Solano Immigration Law Firm, practicing for the last 13 years. I was around when DACA got announced for the first time. And if you applied for DACA before you turned 18 years old and you got approved, and you've kept your DACA up to date, timely submitting your renewals, you're in a much better spot than other people with DACA. And here's why. Under U.S. immigration law, unlawful presence is the time that you're in the United States without status, and it doesn't actually count against you until you turn 18 years old. On top of that, once you have DACA, you're not considered unlawfully present during that period that you have DACA. In other words, because you applied for DACA before turning 18 years old and then you got approved, you have maintained your DACA without gaps after turning 18 years old, you more than likely have 0 days of unlawful presence on your record. That's a huge deal. It means that if down the line, years from now, or maybe today, you need to leave the United States to process a visa, you won't face the 3 or 10-year reentry bars that kick in after you've been in the United States without lawful presence for more than 180 days. I can't overstate how important this is. It's essential. It gives you opportunities that many undocumented folks, including those who have DACA, don't have. You avoided a legal trap just by virtue of timing and when you filed your DACA, which opens so many more doors for you. DACA by itself is not a pathway to a visa or a green card. It is a temporary deferral of deportation without a work permit. Think of DACA as a protective bubble. It lets you live and work here lawfully, but it's not an actual non-immigrant status or a qualifying admission or parole for you to adjust status to a permanent resident. So you can't walk into USCIS and convert your DACA into an H-1B work visa or permanent residency. The law requires that anyone applying for an employment-based green card inside the United States must meet specific eligibility requirements at the time that they file their application, including being in a valid non-immigrant status and having a qualifying admission or parole. DACA by itself, it doesn't provide you with that. Practically speaking, you won't be able to adjust status to a green card in the United States through an employer while on DACA alone, nor can you change status from DACA to a work visa without leaving the United States. I know that can sound disappointing, but here's the good news. Because you don't have unlawful presence, you have the option to pursue visas and even green cards by doing the process a little differently, usually by processing at a U.S. consulate abroad. That idea can be intimidating, but I'll explain how it works and why. In your case, it's entirely doable without the typical 3 and 10-year bar risks. Having DACA, especially since a young age, applying before you're 18 years old, means that you've been able to study and work legally. And you may now have skills that an employer values. Several employment-based visas might be within reach for you, and the key is that you can actually go get them because you won't trigger a reentry bar by leaving the United States. H-1B visas, which require a specialty occupation. If you've earned at least a bachelor degree and have a job offer in a role requiring that degree, an employer can sponsor you for an H-1B. H-1Bs are competitive. That's an annual lottery. But if you're selected in that lottery and your petition is then later approved, you would apply for the visa abroad and then re-enter the United States in H-1B status. Because you've kept a clean, unlawful presence record, you can attend that consular interview for your H-1B without triggering the 3 or 10-year bars that may stop others. In most cases, you should plan to apply in your country of nationality or residence. Interview waivers are now very limited following recent updates. Plan on in-person interview and build that into your timing. As of September 21, 2025, a $100,000 fee applies to new H-1B petitions for workers outside the United States, which may deter some employers from sponsoring you unless you're in a high-value position. Here's a quick note on waivers. You may have heard of the government-created waivers for DACA in 2024. What actually happened is that the State Department clarified that when consular officers should consider recommending existing the 212D3 non-immigrant waivers for certain U.S. educated applicants, which can include DACA recipients. It's not a new DACA-only benefit, and if you've accrued no unlawful presence, you typically won't need a waiver for an H-1B. Let's talk about TN visas. First, Mexicans and Canadians. If you're a citizen of Mexico or Canada and your job fits one of the listed professions, those include engineers, accountants, scientists, teachers, and others, a TN can be an excellent option without an annual cap. Keep in mind, it's a single intent category. Active immigrant intent can complicate things. O1, extraordinary ability. If you have top-tier achievements in your field, think standout scientist or artist or high-impact technology. And O1 is a strong non-cap work visa. E2 treaty investor. If you're from a treaty country, Mexico's one of them. The E2 visa lets you develop and direct a U.S. business. The critical takeaway for any of these, you'll process the visa at the U.S. consulate abroad. And because of your DACA timeline, remember, you applied for DACA before you turned 18 years old and your DACA was later approved and you've maintained it all this time without expiration gaps, you can do this without being barred from re-entering the United States and assuming that you otherwise qualify and meet all the requirements. Maybe you're already working with a great company on your DACA work permit and they want to keep you permanently, or you have a prospective employer that's willing to sponsor you. Typically, the employer obtains a labor certification, also known as a perm, and then files an I-140 immigrant petition. Here's the catch and the opportunity. While you're on DACA alone, you can't finalize to become a green card holder inside the United States. You can't adjust status because you don't have the qualifying status or a legal admission for that step. In that case, once your immigrant petition from your employer is approved and a visa number is available, you would do consular processing, meaning you go to an interview at the U.S. consulate and then you return as a permanent resident. However, if you later obtain a work status like an H-1B or an L-1, your employer can usually sponsor you and can adjust status inside the United States while your priority date is current. You don't need to depart for the final step. As always, double check your personal timeline. Look at the receipt date and then confirm that all these years there's been no gaps in between any of your DACA statuses after the time you turned 18 years old. And look for any factors that could affect your inadmissibility. I've helped clients do exactly this. One dreamer client came to the United States as a toddler, got DACA in high school, and then after college landed a job in a software development company. We couldn't do a simple in-country adjustment of status from DACA to green card. So his company filed an H-1B, he completed consular process interview in his home country, and he came back to start working in H-1B status. A couple years later, that same employer sponsored him for a green card. Because he's had DACA since age 17 with no unlawful presence, he had no issues with the 3 or 10-year bar and didn't need a waiver. He's now a U.S. permanent resident. Also remember that if you've accumulated unlawful presence, for example, you didn't get DACA until you were 20 years old, there might be additional hurdles like seeking a 212D3 non-immigrant waiver for a work visa or other remedies. Maybe under a matter of quintilline, you may also travel on advanced parole and not trigger the 3 or 10-year VAR, but you still need to be screened for all the other inadmissibility issues. I recommend that you make a plan. Keep your DACA current as well. Even a brief lapse after you turn 18 years old can start that unlawful presence clock and it'll keep ticking and ticking. Aim to file your renewals at least 120 to 150 days before your DACA status expires. Many employers don't realize you can safely consular process If you have no unlawful presence, reassure them that your history avoids the usual bars and map out timelines around the in-person consular interview in your home country or country of residence. Consult an immigration attorney. Will verify that you indeed have zero unlawful presence. Will confirm that there are no gaps and will build a travel and filing strategy, choosing the safest time to depart the United States and prepare you for the interview and considering advanced parole when appropriate. Stay informed. DACA renewals continue. And as of September 30th, 2025, there was a development in the federal court regarding the lawsuit DACA that we expect very soon USCIS will accept initial DACA applications after a 4-year freeze. Litigation has kept the program limited with state-specific impact, such as Texas, halting certain benefits like commercial driver's license for DACA recipients. Also, policy details shift. Consular process procedures change, so monitor updates as you plan. One way to stay empowered is by continuing to learn about these topics. In fact, I encourage you to join me in my next video. Can military spouses really get fast-track citizenship? Even if it doesn't describe your situation, it's a great example of how certain immigrants can access special provisions. And who knows, you might have a friend or family member who needs that info. You may become a military spouse yourself one day. In that next video, I'll break down a program that leads spouses of U.S. service members to speed up their citizenship process and why it exists. It's eye-opening and could be essential for someone defending their rights. Every piece of knowledge adds to your toolkit. And as an attorney, I believed informed clients are empowered clients. So thank you for sticking with me through this explanation. I hope you feel more comfortable and confident about your options. And if you're ready to keep learning, I'll see you over in my next video for more discussion. See you there.